Chair Knight.
Present.
Representative Agello. Representative Batista. Representative Bennett.
Here.
Representative Caldwell.
Present.
Representative Casimiro.
Here.
Representative Corvese. Here. Representative Felix. Representative Lombardi.
Yes.
Representative Norrie.
Here.
Representative Place.
Present.
Representative Roberts. And Representative Bella Wilkinson.
Here.
13 present, 2 absent. We have a quorum.
Thank you. Thank you, members of the committee and the public. Today is Tuesday, April 6, 2021, and we're here before the House Committee on Judiciary. We have 9 bills to hear tonight. They're all hearings. There are no bills we will vote on. So the first thing I would request is that we have a motion to hold all bills for further study.
So moved. Second?
It's been moved and seconded. Roll call.
Yes, sir. Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Yes.
Representative Agello. Representative Batista. Representative Bennett.
Aye.
Representative Caldwell.
Yes.
Representative Casimiro.
Aye.
Representative Corvese. Aye. Representative Felix. Representative Lombardi.
Aye.
Representative Norrie.
Yes.
Representative Place.
Nay.
Representative Roberts. Aye. And Representative Bella Wilkinson.
Yes.
The ayes have it.
Okay, the first bill I'd like to take care of tonight is sponsored by Representative Speakman. It's 6173. It's an act related to health and safety. Refuge disposal. It updates and modernizes the Department of Environmental Management's ability to enforce environmental laws, and more specifically modifies the practice regarding a notice of violation. Representative Speakman, the floor is yours.
Thank you, Chairman and members of the committee. This is a bill I worked with DEM on last year and continue to work with them this year. As the chairman said, it allows DEM to administer and enforce its regulations more efficiently, which saves time and money for both the agency and for the businesses that have to whom the regulations are being applied. This deals primarily with hazardous waste and solid waste. Without these changes, violations are now referred either to the EPA or to Superior Court, again increasing the time and the money having to be invested in resolving the violations. And without these changes, the EPA will not approve program updates that are before them now from DEM. I would ask that you reserve your technical and legal questions for DEM. Terry McKay is going to come on, not Terry McKay, Terry Gray is going to come on shortly. Thank you.
Yep. Any questions of the sponsor? Okay, Terry Gray.
Thank you, Chairman.
Hey, Terry.
Hey, good evening. Thank you, Chairman Craven, members of the committee.
You're ready to roll. The floor is yours.
All right. Great, thank you. I'd like to thank Representative Speakman and the other sponsors for introducing this bill, and thank all of you for providing DEM the opportunity to comment on H 6173 tonight. This bill would make several small but very important technical amendments to statutes governing DEM's enforcement of state environmental laws. And DEM strongly urges you to enact this legislation to ensure that Rhode Island residents continue to benefit from efficient and effective enforcement. As you know, I've been with DEM for quite a while, but for the past 40 years, when DEM identified violations of rules, we would issue notices of violation in order and move quickly to either appeals or resolutions, and sometimes both. In order to make that process both effective and efficient, the General Assembly enacted a law over 30 years ago that directs that all adjudicatory proceedings in DEM be heard by our Division of Administrative Adjudication. This worked well for both the state and for the people receiving enforcement actions. However, a Superior Court ruling in 2019 determined that the hazardous waste statute required that all enforcement actions take place in Superior Court. And when we looked, DEM subsequently determined that the solid waste statute included substantially similar language. So as a result, all DEM enforcement actions for both programs are currently occurring through the judicial system, which is costly and more time-consuming for both the state and the alleged violator. This legislation aims to restore the status quo which existed for several decades prior to this 2019 court ruling. So House Bill 6173 is primarily intended to ensure that DEM can continue to enforce the hazardous waste, solid waste programs through the administrative process used in all the other environmental programs. As you know, I think DEM administers the state's hazardous waste program through delegation of authority from U.S. EPA. And earlier this year, EPA wrote to DEM to inform us that the impact of this ruling, this 2019 ruling, had been identified as a significant area of concern. And EPA's letter also urged DEM to pursue these statutory changes with you in the General Assembly to kind of restore the normal status quo back to our program. One of the things that EPA also said was that they indicated they would not approve any program updates or improvements proposed by DEM until this issue with enforcement is resolved. And one of these updates would provide significant relief to Rhode Island's pharmacies, including CVS, Walgreens, and various small community pharmacies across the state, by streamlining rules governing the management of expired pharmaceuticals and customer returns. So EPA is not going to let us do those rules until we straighten out our enforcement authority. So we're anxious to get these technical fixes enacted and move forward with these regulatory improvements. One last thing, in addition to resolving the issues described earlier, the legislation also makes several other minor changes related to enforcement, including allowing DEM to record violations of the oil pollution statute in local land evidence records, which is a practice that's consistent with other enforcement programs. And it also includes language intended to provide DEM with greater flexibility in entering into remedial agreements, which is super important for cleaning up brownfield sites. Finally, it includes language amending the amount of time that alleged violators have to appeal an enforcement action to be consistent with other statutes and existing practice, and to streamline the process for collecting penalties resulting from violations. The AG's office also supports this bill and has provided a letter of support. So once again, thanks for the opportunity to provide our support for this bill, and I'd be happy to answer any questions you or members of the committee have.
Terry, Dr. Corvese has a question for you.
Good evening. These may seem like very simple questions, and maybe when I look at this, basically what you're trying to say is you're trying to codify into law the status quo because of something that happened in 2019. Am I correct?
That's correct, yes.
Okay. So on the first page, on line 4, you use the adjective criminal for the noun violation. Why? So that must be differentiating the difference between a criminal and a civil violation. Am I correct?
Yes.
So why was it necessary to put criminal in there, and where would the civil violations be prosecuted?
The civil really what we're doing is we're trying to differentiate the criminal violation, which clearly has to be done with the Attorney General's office in a court setting, with the administrative violations that would be done through an administrative action under the Administrative Procedures Act, and then would be appealable to our adjudication division. The decisions from our adjudication division are then appealable into Superior Court. So that continues kind of the civil side of life. So that's the distinction that I think is made there.
And still on that first page, on line 17, it says, starting from 16, institute and prosecute in the name of the director by either the director or by the Attorney General. So either one of those individuals can prosecute, correct?
That's correct, yes, sir.
So when would it be the director or the attorney general? Would they both be prosecuting the same type of violation, or would there be a differentiation?
The differentiation would be when we're doing administrative enforcement, then it would be the director that would do that. When we get into civil litigation, then either the attorney general or the director could initiate an action in Superior Court. But when we get to criminal violations, only the attorney general can enter Superior Court and take those actions.
Okay, so it seems, if I've understood what you said correctly, that there are two separate subsets, one for the director and one for the attorney general.
Yeah, and there is concurrent jurisdiction on the civil side.
Okay. That's why you said by either the director or by the attorney general.
Yes, sir.
Thank you.
Jason?
Thank you. Sir, this is Jason Knight. Can you hear me?
Yes, sir.
All right.
Good evening, Representative.
Good evening. I just have a question for you, and I'm just curious. On page 1, down on the last 2 lines, the proposed language changes the standard for issuing an injunction to get rid of irreparable harm, or what is commonly known as part of the balance of equities. Why do you need that?
I will have to get back to you on that. That's something I want to make sure I get that answer exactly correct. That would be something that one of our attorneys would have to give you the direct answer on.
I appreciate that, because when people are seeking an injunction, which is a restraint prior to a litigation on the merits, you're supposed to show irreparable harm, balance of the equities, you're likely to win at a trial on the merits, and the overall public policy. Did I get all those 4 of those?
You did.
Those are time-honored elements, and this line carves out one of them, so I'm curious. And if you could get back to us, that'd be great.
Yeah, I will. Thank you, Representative, for pointing that out. I'm just not an attorney, so I don't know the answer to that one. I want to get it right.
Gotcha, thank you.
Yes, David Place. Representative Place.
Hey, Terry, how we doing?
Very good. Good afternoon, Representative.
So I want to highlight the sections that Representative Knight mentioned, as well as the section on page 2, lines 13 through 15, and then wrap it all up with a section back on page 17, lines 5 through 8. I don't know if you're following me on that or not. If you could go through, take a look at those real quick.
Yeah, I think I followed the first section, and then the second section talks about proceedings for enforcement, line 17. Lines 13 to 15, you said.
Yep. And then again, you roll back up to page 17, lines 5 through 8. So as I read them, and as friends of mine who are lawyers read them, they interpret that to mean that if an individual is fined and they agree to the fine up front, and then you guys go to seek an injunction in court, that you can use the fact that they accepted that fine as evidence that they can't appeal that injunction. So could you relieve that concern that myself and a couple of the lawyers have based on the combination of language in those 3 sections I just referenced?
So on the page 17, you're talking about the language that's in line 6 through 8, I believe?
Yes.
Okay. What that language applies to, that if someone does not exercise their right to an adjudicatory hearing, they don't request a hearing, then the proposed penalty shall become a final order immediately upon the fact that they've waived their appeal. And at that point, then we could go to Superior Court for enforcement of that as a final agency order. That's what we've always done. So if somebody doesn't appeal an action, yet they don't comply, including don't pay the penalty, then our recourse is to go to Superior Court to enforce compliance at that point.
And that's the whole point, right? You're trying, so individuals who realize that they're not going to, or believe they're not necessarily going to get a fair shake in your administrative proceedings, they just choose to just appeal directly to Superior Court. You're just stopping them from doing that now, aren't you?
No, they don't. What happens is people have tried that and they've appealed directly to Superior Court on an action, and the court usually tells them, look, you have to appeal back at DEM. That's your first right of appeal. And then it gets pushed back to the hearing. We go through the hearing. If they don't like their decision at the administrative hearing level, then they have their right of appeal and standing at Superior Court.
All right, so just answer my question, yes or no. If I go ahead and accept the fine, right, up front, say I accept the fine up front, but then you take it to Superior Court in order to seek an injunction, does that mean my accepting that fine can be used as evidence to automatically disallow, for lack of a better term, my standing to appeal your attempt to place an injunction on me?
Let me get back to you on that one. I want to make sure I get that answer completely correct. So let me talk to our attorney, Deputy Chief Legal Counsel, Susan Forcier.
Because that's, and I'm only saying that, I understand there are attorneys in the room that are shaking their head no, but I've also found other attorneys that have told me yes when I went through and read this thing. So I think that's a big concern for me.
So my understanding is that's not the way the system works, but I want to just get you a definitive answer on that.
Well, and like I said, that's my concern, because the way these folks that have read this, they read it to mean that if they do submit to the fine, that they lose their ability to appeal the injunctions that you guys take to Superior Court. So that's my primary concern with this legislation. So it's not just a technical change that, there's a pretty drastic change in there. So I'd be careful. I'm obviously concerned enough with the legislation to bring it up. And then my last question is, why Providence? Why not any other of the courts throughout the state?
I think that's just where we went. I don't think there's any specific reason for that. That could be any Superior Court. I think that's just where we vested jurisdiction for this.
Again, I just point out, I just think restricting it just to one particular court, I would say, is an undue burden on the other parties. But I think we've established, the courts, the way we did geographically speaking, to accommodate a lot of different folks in a lot of different ways. And I think restricting this just to one court does do away with that idea.
Okay. All right. Thank you. Well, let me ask around on that one.
Mr. Chair?
Jason Knight has got another question for you, Terry.
Through the chair, actually, I haven't answered that question. There's just more judges in Providence County. In the outlying counties, there's one judge sitting on the civil calendar, which is where this would go. And you're going to get bogged down. I'm not saying Providence operates at light speed by any stretch of the imagination, but they're able over there to have more flexibility to deal with these kinds of cases faster, in an expedient manner, because you're going to have a judge who is trained up, essentially, by virtue of handling the cases. So going to Providence is a better deal, it's a faster deal than having to go to the outlying counties. And to answer your previous question, I mean, this generally tries to follow the Administrative Procedures Act. So in your situation where somebody is fined by the department and then chooses to pay the fine, I see that you're troubled by the injunction language, and I get that, but that language, you wouldn't necessarily have that situation. If somebody is fined and they don't appeal, then DEM can run to Superior Court to enforce paying the fine. If DEM says do something else, as in I want you to do something, then they could, and someone doesn't appeal, it's a final order, then they can run to Superior Court to say, make it happen. But if somebody's truly aggrieved by a finding of DEM, then they have to appeal. They're the ones who take it up to Superior Court, and then it's a whole new ballgame.
Thank you. And if I could just add, in 34 years, I've never seen anybody pay the penalty and appeal the performance aspects of an order. They appeal the whole thing usually.
Well, and I guess that's, like I said, just the way, the folks that I had look at this interpreted it, is that their concern is that it does allow for the payment of the fine to, in essence, be used as evidence that the person's kind of just copped to it and that you have no other way, you have no other recourse beyond that, once you've already pled guilty, for lack of a better term, by agreeing to the fine. So that's in my layman's terms, that's the way that I took the explanation from the attorneys that I talked to, and I would just hope that we could, clarify that in some way, because we've got differences of opinions from different attorneys.
Okay, any
Will
further
do.
questions of Terry? Terry, you have something else you want to say?
No, that's it. I just said thank you.
Okay. All right, that would conclude testimony on House Bill 6173, which will, I think... Thank you. I thought Pat Morgan was here. She said... Oh, it is Pat. Okay. The next bill is sponsored by Representative Morgan. It's an act related to courts and civil procedure, and procedure generally, and particularly causes of action. It grants immunity from civil liability and professional disciplinary action for any action or inaction arising out of a disaster or declared emergency when acting in good faith. Representative Morgan, the floor is yours.
Thank you, Chairman, and thank you for giving that summary for me. And thank you, everyone on the committee, for listening to me and considering my bill. Over the last year, we have found out just how capricious and unruly a microscopic organism can be. A lot of companies have done everything they've been asked to do. They've taken temperatures, they've written down contact information, they've put in plexiglass, and they've ordered gallons and gallons of disinfectant. They've done everything that they were asked to do. And yet, employees and customers still got sick. This would shield those companies or individuals from worrying about the threat of civil liability or professional discipline if they did everything right. It does not shield them if they acted with recklessness or willful disregard. Rhode Island has a reputation for having a hostile business climate. And this is one thing that we can do to resolve that or to make it better. We all know that we have restaurants and other businesses, organizations, entities in our districts that have really suffered from this pandemic. A lot of them have gone bankrupt. In West Warwick, which doesn't have a thriving downtown like North Kingstown or East Greenwich or even Warwick, we lost 64 small companies in the last year. They have been suffering, and the last thing they need to do right now is hire lawyers to fight a frivolous suit. I'll call it frivolous. Is that all right, Chairman? So this, again, it shields them, but not if they are reckless or if they disregard any part of the guidance, the executive orders, the regulations that are passed down. Questions?
Any questions of the sponsor? Seeing none, we have two witnesses on this bill. The first one is Roy Whalen.
Mr. Chairman, I had a question.
Oh, I'm sorry, John.
That's okay. That's okay. Thank you, Mr. Chair, members of the committee. How are you, Representative Morgan? Hope you had a good Easter. Can you hear me?
Yes, I can. Hello.
Oh, I'm sorry.
You wanted to know if you had a good Easter.
Oh, yeah, it was good.
Okay.
It's good.
So we want to create a protective veil for these actions. Representative, do you think this would also apply to business interruption portion of the insurance policies, whereas, the insurance companies are saying that there's an exemption with with things of this sort, meaning the COVID virus. So would you agree that that needs to be looked at as well?
I'm sorry, I can't hear you very well.
Representative Body was referring to the causes of action that could arise out of business interruption, and particularly whether or not an insurance company would be held liable as a result of COVID-19 or an emergency declared by the governor or whomever.
Geez, I'm not a lawyer. This actually is based upon laws that have been passed already in several states, so Utah, Texas, a couple of others, Florida. I can check to see what they're doing as far as insurance companies being liable for interruption of business. Is that it?
Yes.
I'd have to check. I don't know. I'll be honest, I don't know.
Okay.
Yeah, because I think that when we start interfering with businesses, insurances and things of that sort, if we're going to do it, I think we need to look at it in total. And I think the business interruption portion is, to me, 1,000 times more important, because in many of our cities and towns, as you know, Representative, many of the people that work in those restaurants and clothing stores and, whatever, live directly in the neighborhoods. They pay rent, they buy their food there, they buy their clothes there, they purchase their gasoline, whatever. So it's just, many people were not able to, they were collecting, yeah, but, many of these people, sometimes they make $900, $1,000 a week. And, when rents are where they are skyrocketing in Rhode Island, you saw the article in Sunday's paper about housing, and that this state, for some reason, everybody wants to live here, and that's good. So anyway, that's my concern. So
Yeah.
maybe it's a statement as well as a question. So yes, if you could do that, I'd greatly appreciate it. Thank you.
Maybe I can address this through the chairman. When someone buys interruption of business insurance, doesn't the policy kind of set down what the parameters of that?
It does.
Yeah, so
But you would.
it would seem to me that if your insurance policy covers pandemics and emergencies, that this law wouldn't relate to it. I mean, I will find out what the other states did, but
I'll speculate that.
you have contract law.
Yeah, maybe the contract lawyer would say that we've been indemnified from liability as a result of this.
Of this law.
This bill.
Okay, I will check.
Thank you.
Okay. Any other questions of the sponsor? All right, Roy Whalen, is he on the phone? Mr. Whalen, you're on the air.
Thank you, Mr. Chairman, members of the committee. I am Rory Whalen. I'm the Regional Vice President of the National Association of Mutual Insurance Companies. I appreciate the opportunity to speak in strong support of this legislation. And let me first thank the sponsor, Representative Morgan, who really articulated, I think, very clearly and accurately the need for this legislation. I would ask the committee to consider that America's resiliency has been tested in this crisis unlike any other in recent memory. And we all, as Americans, have rallied to protect and support one another in many ways. Likewise, professionals, businesses, non-profit institutions have significantly contributed to this battle by keeping Americans employed and ensuring safe access to critical goods and services. And that's why this legislation that provides immunity from civil liability for entities that have operated in good faith, and I think that is the key, and the sponsor did mention this, that is the key to this legislation. Businesses that have operated in good faith pursuant to health and safety guidelines deserve this protection. As we all know, those safety guidelines and protocols changed in many ways, many times, and businesses and others have put a great amount of time and effort and money into comporting with these changing protocols. And therefore, businesses that went to that considerable expense and effort should not face the threat of unfair litigation. Again, to be clear, this bill does not provide immunity for reckless actions, gross negligence, or willful misconduct. This legislation simply recognizes that businesses and other entities that did the right thing merit protection from unfair lawsuits. And I would just, in closing, mention that more than 30 states have enacted similar laws as a result of this pandemic and its aftermath. And I would also say that this is a great opportunity for Rhode Island to lead where Washington has lagged. The Congress has endeavored to enact similar federal legislation for more than a year without any success, and prospects for passage in Washington are rather dim. Approval of this bill would memorialize in statute that Rhode Island will support business investment and job creation by granting legal protections to responsible businesses. I thank you for this opportunity, and I'm happy to answer any questions.
Any questions of Mr. Whalen? Seeing none, thank you, Mr. Whalen. The next witness is Mark DeSisto. Welcome, Mark. You on the line?
Yes.
Okay. Please feel free to testify on Representative Morgan's bill.
Thank you very much. Thank you, Mr. Chairman and members of the committee, for the opportunity to speak on this bill tonight. My name is Mark DeSisto. I'm with the Rhode Island Association for Justice, and we are in opposition of House Bill 6085 because it's an extremely broad bill. This bill would grant immunity to anyone who claimed they were acting in accordance with or under the guidance of any federal, state, or local regulation or order. Also, anyone who claims that they were acting in good faith. This bill basically gives people, governments, and corporations a free pass so long as they claim they were acting in accordance with the government directive and that their own opinion that they were acting in good faith. This bill is overly broad, and it's a free pass for negligent or even reckless behavior. I'm keeping my testimony brief. I'll answer any questions at this time. Thank you again very much for the opportunity to speak.
Any questions of Mr. DeSisto? Any questions of Mr. DeSisto? Seeing none, that completes testimony on...
You know, Speaker,
Oh, sure.
I disagree with Mr. DeSisto's characterization of this. The entities, whatever they are, will have to demonstrate that they did follow the executive orders and the regulations and the rules that have been passed down, and they've done it in good faith. It's not overly broad. They are going to have to demonstrate it. But the problem is, if they're being sued, they can't use that money to recover. Right? We know that in Rhode Island there are a lot of companies that are hanging on by their fingernails right now, and it will take them at least a year, maybe 2 or 3 years to get back on their feet. The last thing they need to do is take some of their precious financial resources and use them to fight civil litigation when they should be using it to get their employees back in, get customers back in the doors, and start making their companies healthy again. But it's not a free ticket. If they were reckless, if they had willful misconduct, they're not shielded. I think the companies in Rhode Island that I know really have gone above and beyond to follow all the executive orders and the rules, and I think they need this help. Thank you.
Thank you. Okay, that completes testimony on House Bill 6085, which brings us to, we're going to begin Representative Noray's bill 5989 so that we can have him introduce it, put it in play, and have one witness testify who's an expert and from out of state. So, Representative Noray's bill is an act related to criminal offenses, mandatory vaccination agreement prohibited, and it prohibits discrimination against individuals who refuse to be vaccinated. Representative Ray, the floor is yours.
Thank you, Chairman. You always do such a great job of explaining the bill, so there's no need for me to take any additional time. Who would have thought 4 to 6 weeks ago some of the concerns of this legislation are going to be front and center today and be addressed? The reason I introduced House Bill 5989 was not to cast aspersions on the COVID vaccine. I believe it's been welcome news for those who have been living in some level of fear or apprehension for over a year. But fear is always the first step towards discrimination, and any policy that would reward those who receive a vaccine or punish those who haven't had this vaccine, there's no place in our society. And I don't think we should allow any individual or institution to discriminate based on a vaccination. Job hiring, school enrollment should be commensurate on the talents and abilities of the workers and the students who seek them, without any other consideration. The COVID pandemic has been a very real and serious threat, but that threat should never, ever make us lose our common sense, or more importantly, give us a reason to discriminate against one another. I look forward to the conversations that we're about to have, and absolutely am open to discuss any necessary amendments. I realize that this bill needs work. It's a first draft. That's why it's held, as always, and we can work on this bill to make it better. Before any mandates occur, let's have this important discussion. And I've asked Ralph Hazelhurst to testify so we understand the process and the importance of being ahead of this. Thank you.
Any questions of the sponsor? Oh, yes, Dave.
Representative Norrie, I can understand if you're immunocompromised and you cannot get the vaccine.
Should be right with you.
What's that?
Oh, John is on.
I lost my train of thought. But if you're carrying a disease that's highly spreadable, and you're going into a place such as a hospital, a nursing home, a school, and you just outright refuse to get the vaccination, I don't know if that's really discrimination. It could be reverse discrimination to the person that's going to get sick because you didn't get your vaccine. It's important that we get rid of this virus. We have to reach herd immunity. We have to, get vaccinated. And if there's people out there, look at the masks. Mask, for example. There's no flu. The mask is protecting us from the flu. The shot, the vaccine, protects us from the virus itself, the COVID virus. And if you're a hospital or any of the entities I just said, I would question, letting a person into that facility if they're not vaccinated.
Representative Bennett, all great questions, but again, a person shouldn't lose their position of employment. They should not be in fear of not being able to buy property because they're concerned that, again, a mandate may come down by a bank that they're going to put a question on an application for a mortgage, have you been vaccinated? Because they're concerned that the person hasn't been and may not pay their bill. Again, I am open to all discussions. I realize there are certain amendments that are already, certain vaccinations that are already required, and I'm willing to make the adjustments to this bill to fit that. But again, I've been told that there's some things coming down the pipe right now where there's going to be, people may be taken off the opportunity to work based on the choice of not getting the vaccination. And those are the things we should not be able to be in fear of feeding our family because we, for whatever reason, choose not to get a vaccine that right now, that the CDC from their website says COVID vaccines are not mandated under emergency use authorizations. And we're going to, and it says the Food and Drug Administration does not mandate vaccination. However, whether state or local government or an employer, for example, may require or mandate a COVID-19 vaccination is a matter of state or other applicable law. They're putting it on us to have this discussion, and that's what I want to do. I want to have this discussion.
Thank you.
Thank you. It is a great question.
Yes, Vice Chair McEntee.
Thank you, Chairman. And thank you, members of the committee. I have to agree with Chairman Bennett on this. You know, for years, we have had schools, you can't let your kids into school unless they've had certain vaccinations. This is to protect the majority. If someone so chooses not to vaccinate or not to vaccinate their kids, then I guess they can do online. The colleges, I mean, my area in South Kingstown and Narragansett, we've got to get those kids vaccinated. I mean, when you send your kids to college, and you will find out soon enough, you have to get the meningitis vaccine. You have to have everything up to snuff. Or they don't let you, it's like, see you later. Come back with your vaccine and we'll let you in. So, I mean, congregate-style living, like dormitories, like classrooms, like nursing homes, I think they have every right to refuse a person who doesn't want to get vaccinated because they have to protect their patients. Hospitals is another place. You have to protect your students. I mean, you know, if somebody chooses just because they don't want to get vaccinated, I cannot be with you on this. I just, you know, if you're working in a restaurant and you don't want to get vaccinated and your boss feels everyone should get vaccinated, I think there's a problem because you're around too many people. You're around the food. You can spread the virus. I mean, this is for the greater good. And we as legislators, I'm on the COVID-19 task force with the House, and it's our job to help promote the vaccine. To take up a bill like this to find a loophole for people not to get the vaccine when we're in the middle of a pandemic, it just seems wrong to me. I'm sorry. We need to get everyone to get the vaccine as much as possible. And which vaccine is good for you? The one you can get as soon as possible.
Representative, you know as well I'm on the COVID vaccine task force, and I'm not preaching that people should not get the vaccine. So I have my mother's permission to tell you that I made her appointment and I took her to get the vaccine. That, again, I'm not opposed to the vaccine. Again, I think people are missing the point with this legislation. There are people out there for their reasons that feel that this vaccine has been, for whatever reason, rushed to market, whether it's, again, an emergency use, and the CDC is saying they're not going to mandate emergency use vaccines, and they're leaving it up to us to discuss this. We're here to discuss this. That's what we're here for.
But
and
you
again,
want to make a loophole.
If I may finish,
Okay.
I'm not making a loophole. I'm trying to make a piece of starter legislation that maybe we can work on, that people can work together to accomplish a task. That's what all the legislation we put forward all the time. It begins, it's worked on, and it either doesn't go anywhere or it does. And that's all this legislation is here. Let's have this conversation, because when this legislation was drafted, none of these colleges or universities were mandating vaccines. This legislation was ahead of the curve, right? With anticipation that, again, there could be mandates coming forward that would affect people who, for their reasons, have a difference of opinion. And I'm not saying I don't think people should get vaccinated. Not what I'm saying. I just got my flu vaccine. This is not an anti-vax bill. That's what I want people to understand. Okay. But we have to have this discussion.
I think it's premature. So
well,
we will
again, I'll
agree to
disagree with
disagree.
you because there's colleges and universities that are coming out and going to mandate.
They have to do it. They have to do it. These kids are living in dormitories.
Well, then we have to have
They're
this
spreading the
discussion.
virus. It has, so, okay. Thank you.
Vice Chair Knight.
Thank you, Mr. Chairman. I appreciate, through the chair, Representative Norray bringing this bill and offering it up for a conversation. And so in that vein, I'll just throw my 2 cents in. I think this is one of the hardest issues of public policy, and it brings up hard questions about where does government power end. I believe it ends at the surface of the skin. That's what informs my position on a lot of these issues that have to do with bodily autonomy, particularly choice. But there's a competing angle in this particular debate because everyone's got the right to bodily autonomy, but everyone also has the First Amendment right to freedom of assembly, which means you get to pick and choose who you can be with and not be with. And in a place of public accommodation, we have made some decisions that that your First Amendment rights are restricted because you can't say, I don't want to hang out with you in a place of public accommodation because you're a different color, or you're a different heritage, or you have a disability. But those are all immutable qualities. And those qualities, by virtue of, they don't affect a person, right? There can be a person who has some protected class about them, let's say gender, and their gender doesn't affect me, and so we've made a law that says, we're going to curtail your right of assembly around that. But with sickness, contagious sickness, it's different. And you can have someone in the same room who may be able to negatively affect me by virtue of breathing the same air. And I think that history has taught us that it's one of the oldest problems, but it's one that human society has figured out, which is we come together and we take steps to preserve the group. We protect the flock at the expense of the sheep sometimes. We have mandated school vaccinations for kids going into schools. We have a number of different areas where you have to, if you're going to live in a congregate setting, you got to have a vaccine. And in this particular case, while I appreciate that the vaccines that are upon us for the coronavirus have been developed with incredible speed through new technology, we are in the midst of like a giant clinical exercise. So those shots are in hundreds of millions of people's arms, and we're not seeing crazy symptomatic responses. And I know, because I've gotten the emails, somebody's going to tell me there's been vaccine injury, a few people have died, but it is, even if it's true, it is like fractions of a percent. Not to say that any life is worthless or not to be counted, but when we're talking about the greater good, we're talking about the greater good, and these particular vaccines work. Moreover, there is an argument that if we fix the pandemic, we fix our economy. If we fix the pandemic, we get back on our feet. I hesitate to say this, but I really do believe it. I think it's people's patriotic duty to get this thing if they can, so that we can all get back to normal. So that's my outlook going in. I wonder if there's some compromise around a bill like this to create medical exceptions, right? If you can't get the vaccine for whatever reason, I'm not going to bar you, but maybe you take some other protections. Maybe you come with a mask. I don't know. But I want to acknowledge it's a hard question. I also want to acknowledge I think that we've come up with a solution over human history. That's all I got to say. Thank you.
I think Representative Casimiro had her hand up before you, Doc.
Thank you, Chairman. I do believe that it is our job to promote vaccine. I do think it's our patriotic duty to get the vaccine. This isn't about mandating the vaccine. This is about not firing someone from their job because they choose not to get it. It's a lot of people in this room supported reproductive health care. That's a woman's choice. Why is this different? Why is this different from choice? So I think there's a lot of discussion that can be had here tonight. It is our job to promote the vaccine. I'm going on record saying that I got the vaccine. My family is fully vaccinated, and I'm proud of that. But it's not our job to mandate it, and it's not our job. It is our job to protect the economy, and it's our job to protect people from getting fired because they choose not to get it. Thank you.
Doc?
I'm going to wade in very slowly here. First of all, for the record, I did get both. I got the Moderna, both. And I did that because I made an individual decision that I not only had a responsibility to my family, but I had a responsibility to my patients. So, but I think, unlike First Chairman the McAtee, I think this is a conversation that is more than appropriate at this time and is not premature. Many times, as I mentioned to my colleague, Representative Knight, many times in this House, we close the door after the horse has left. We have a history of sometimes knee-jerk reactions to tragedies that happen. There are times like this where we try to be proactive as opposed to reactionary. I think Representative Noray's bill is more than appropriate and certainly engenders discussion. Now, just because I decided to take the vaccine doesn't mean I think everyone should take the vaccine. I think the conundrum comes up with school-age children, be it college or be it public school. And I've had that discussion with Representative Noray, and perhaps that's one of the subsets of amendments that we could discuss surrounding this bill. But I do agree with Representative Noray and Representative Casimiro that basically, as for an adult, you have that individual right whether or not to have that vaccine, just as you have the individual right not to take the flu vaccine. Now, right now, in this particular period of time, and I'm not an epidemiologist and I don't pretend to be, the mortality rate for, and depending on who you talk to, they may differ with this, but I'm going to go out on a limb and say the mortality rate for COVID is far higher than it is for the flu. And why? Because we've managed flu over the years. We haven't eradicated it, but we've managed it. I'm hoping that sometime in the future, perhaps the near future, between the vaccines and herd immunity, for whatever it's worth, we'll be looking back at COVID the way we're looking at flu. And hopefully, we as a society do not force individuals to take the vaccine. I'm talking about adults. I think that the school-age children, the school population, I think we have to discuss that, okay? And, you know, and by the way, and tangentially to that, I think there are a number of issues with regard to school-age population and different subsets of children who come into the public schools. There has to be a uniformity, perhaps, of vaccination, because there is certainly a public health concern. But I don't think, I think that Representative Noray's bill, as he said, is a first draft, and I think that it does deserve discussion. I think it deserves a lot of deep thought. And but I think there's more than a modicum of merit in what he's trying to achieve.
Representative Colo.
Thank you, Chairman.
Right with you, John. I'm sorry.
Oh, that's okay. Thank you. Rep. Noray, I will say I have two things about the bill that I want to say that trouble me, but I do agree with Jason that, you know, we do need to make sure that folks who are medically compromised and cannot get the vaccine, you know, still can go out in public places and have jobs and have a way for us to figure that out. The two things that trouble me the most about this bill is grouping in people who choose to not get a vaccine with other protected classes like people, gender and race, things that they cannot help and that are not choices. You know, I'm sure that you didn't mean any offense or disrespect by grouping those people together, but you know, it's actually, in my view, the height of privilege to choose not to get a vaccine. And so I don't think this is an appropriate place to be talking about people who choose not to get vaccinations. You know, none of us chose to be the country we were born, our skin color, our gender. We're making a decision not to get a vaccine and to put other people in harm's way when we go out in public. So that's my first issue. My second issue is that, you know, actually I don't think we're in a place to tell business owners that they can't do something to keep their employees and their customers safe. I think business owners need to be empowered to decide that, you know, they are going to keep their employees safe and all of their customers safe. And it's not forcing people to get a vaccine. They can choose not to do it, and they can go work somewhere that is not a hospital or a nursing home. You know, I think a lot of you know most of my family is in the healthcare field, and they suffered huge amounts during this pandemic of their staff and of their employees. And the idea that we would think it was okay that someone could keep their job inside a nursing home without getting vaccinated with people there blows my mind a little bit with some of the conversations we've also all had about the urgent need to keep patients and vulnerable populations safe. So I'm glad to hear that you think this is the start of a conversation about this issue. And those would be the two reasons that I am strongly opposed to this bill, and will also add my thoughts that everyone should get vaccinated as soon as possible. I received my first dose of the Pfizer vaccine on Saturday, and I am elated still by it. So thank you, Chairman.
John Lombardi, or Representative Lombardi.
Thank you, Mr. Chairman, Representative Nareg. These would be some of the questions that I would be looking for answers to, and again, reason why I'm aware of a lot of this stuff is because of my what I've been looking at with regard to business interruption. So, number one, how safe are they? How safe are these vaccinations? Can these vaccinations cause serious and sometimes fatal side effects? What are the ingredients in the vaccines? Are they safe with the amounts being used? Do they have harmful ingredients? You know, do they contain aluminum or formaldehyde or things of that sort? You know, and how would that affect? And Representative Norrie, I'm not expecting an answer on these. I'm just giving you what some of the questions that, you know, I think should be at least addressed some way. Major medical organizations are endorsing the vaccines. The government, but however, the government should not be intervening in personal medical choices. You know, that's the balance on those two. Adverse reactions to vaccines are extremely rare. Mandatory vaccines, they infringe upon constitutionally protected religious freedoms. And, you know, how will that be addressed? Will they be addressed? Vaccines protect the herd. Vaccines can contain ingredients some people consider immoral and otherwise objectionable. You know, we saw that recently with certainly one of the, you know, with they said they had fetus and, you know, human blood plasma proteins and things of that sort. You know, how true is that? Is it not true? I don't know. Vaccines save children and their parents time and money. You know, on the other side, people may say vaccines are unnatural and natural immunity is more effective than vaccination. You know, back to the herd mentality. Vaccines protect future generations. However, the pharmaceutical companies, FDA and CDC, should not be trusted to make and regulate safe vaccines because that's their industry, that's how they make their money. You know, it would be like a bunch of lawyers, I guess. Vaccines eradicated smallpox and have nearly eradicated other diseases such as polio. However, diseases that vaccines target have essentially disappeared. Did they disappear on their own? Is this really is this a disease or is this just a virus? Vaccine preventable diseases have not disappeared, so vaccination is still necessary. Vaccines provide economic benefits for society. And, you know, and we can go on, but that's just like 20 questions right there, Representative and members of the committee, that, you know, I would look to at least have some kind of, you know, obviously none of us may have the answers to those questions, but the expertise to get the experts to inform us as to, you know, what, if, where, when, and how, because, again, I think, well, I certainly admit, I did get my shots, by the way, in case anybody's wondering, as did my family, and I just think that, you know, we have to start somewhere. This is something new, and we need to get the answers. So thank you, Mr. Chairman, members of the committee. I appreciate it.
Yes, Representative Norrie.
Thank you. So through the chair, Representative Knight, great questions, and again, we're having the discussion. That's why we're here. Representative Corvese, again, thank you for the information you're providing. Representative Caldwell, I just want to say I understand your concerns. I understand your objections to the bill, and you're not the only person that has those objections. But again, we're having this discussion, and we're going to try to work for everybody, right? We're going to try to work for the benefit of everybody. And Representative Lombardi, also, thank you very much. They're great questions, and I'm hoping that through this process we can answer all of those questions for you, and if not, we will find the answers. And lastly, Representative Casimiro, I didn't acknowledge you earlier, but again, thank you for your support and again, the information you've provided.
Representative Agello.
Thank you, Chairman Craven, and thank you to all of you, particularly the sponsor, Representative Norrie, for introducing the bill in a way that really invites discussion. I think that's just wonderful. Congratulations on that.
Thank you.
I share many of the concerns of members of the committee. I share particularly Representative Caldwell's concerns of placement in this bill in our discrimination law. I think that one's choice to have a vaccination or not is an individual choice, unlike where one is born, or what one religion is, or the color of one's skin, or one's gender. So I don't think it belongs in that section of law. But we do have law that allows parents to refuse to have their children vaccinated for measles, for instance, because they have a religious objection to vaccinations. And I think that it makes sense to continue that and maybe make that clear for adults too. But like Vice Chair Hagan-McEntee, I see the real importance of our colleges and universities being able to say students must be vaccinated if they're going to live in the dorm or the fraternity or the sorority house, if they're going to be in classrooms in close proximity in September. I heard from Representative Speakman, I think just the other day, that Roger Williams plans to require that in the fall. I expect that Brown University, which is in my district, is doing something similar. I just haven't heard that yet. And I think that makes sense. So not only school children, I think it makes sense to require vaccination for something as serious as the COVID vaccine is. I also think it makes sense for colleges and universities to require vaccine of students returning to campus. It's, you know, they could attend school virtually if that's their choice. And I think that also for healthcare facilities and healthcare providers, doctors' offices, to say, I want my staff to be vaccinated. They're one-on-one with our patients. I had the experience several weeks ago going into the vets when some people demonstrating for the nursing home staffing bill were outside the vets and talking to two women, both of whom work in nursing homes in Providence. And one of them had had the shots and the other one had declined. They both work in nursing homes. There's been no requirement. I have heard that the take-up of vaccines when offered to nursing home employees is substantially less than 100%. And I think probably there aren't enough potential employees for nursing homes at this point to be saying, I'm going to fire you if you don't get a shot. But at some point in the future, nursing homes might be and hospitals and doctors' offices, et cetera, might be in the position of saying, this is so important, and I have the potential employees that I'm going to say, you have to get the vaccinations or you can't work here. And I'm not willing to say right now that that shouldn't be the right of an employer. So I think it's a great discussion, but there'd be have to be an awful lot of carve-outs for me to accept it. And I think you need to move it to another section of law.
Thank you, Representative Agello, and I actually should have addressed Representative Caldwell, her first and strongest objection to this. I absolutely had no intent whatsoever to diminish the discrimination portion of the law. Again, but my intent is that people aren't selected or picked out for not getting this, and that's the cause. So the cause of their, again, not getting a loan, the cause of their employment status would be because of their choice. And that's why I felt it was best to go in here. So again, we can have a difference of agreement or a difference of opinion. And again, I welcome all the discussion that this bill is bringing to the table this evening. Thank you.
Representative Felix.
Thank you, Mr. Chairman. I want to thank Representative Norrie, as others have said, in terms of bringing over this bill and having these discussions and the great points that all of my colleagues have made regarding this legislation and our potential legislation. And I just want to make one point, is that the Equal Employment Opportunity Commission in many, many instances has issued guidance and advice in terms of what happens when obtaining a vaccine, such as COVID-19 and others, in terms of employment rights. So I'm a little bit concerned in terms of, I do want to protect employers, because it's, especially in the middle of an economic crisis, in this pandemic, losing your job is the last thing we want folks to do. But we also have to balance the public's general well-being. But like I mentioned, the EEOC has established guidance mandating vaccines with certain exceptions, meaning the ADA and religious beliefs. So I'm a little bit concerned in terms of, should this pass, what happens then being contrary to what the EEOC guidance is. So that's one point. And again, I understand the concerns around this vaccine. I mean, I come from a Latinx family, and there's a lot of misconceptions and mistrust around the vaccine because a lot of misinformation out there, and also because of the history of the United States when it comes to vaccine and people of color, right? So I don't want to minimize the fear that folks have, when it comes to vaccine, but in my personal opinion, I mean, we have to think about the greater good, which is our whole community, and think about hopefully seeing the light at the end of this tunnel and getting COVID to be in our rearview mirror. So those are my comments. I just want to thank all my colleagues for the really great discussion around this bill and starting this conversation.
Okay, David.
I think when we start looking at this, I'll refer back to what Representative Agello was talking about. The nice thing is, we're not going to have to worry about our nursing homes and our hospitals making it mandatory, because if they did, they would lose up to 40% of their workforce. Because as of right now, medical professionals in nursing homes are rejecting this up to 40%. In Ohio, it was 60%. 60% of the folks who work in nursing homes made a decision not to take the vaccine. It's because they just don't trust where it came from. And I think it's difficult for us to allow, I don't want to diminish a machine shop that I work in, but I think it's hard for us to allow a machine shop to mandate that their employee get vaccinated because they don't have trust in the vaccine. If our medical professionals still have not, and up to, like I said, Ohio, I think the statistic was 60% of nursing home workers didn't take it because they don't trust it. The reason why we get vaccines so easily. The reason why folks accept vaccines so easily is from a generational trust. I think myself and Representative Knight understand when you go in the military, one of the first things you do is you walk through a line and they turn you into a pincushion. And you accept that because through generations of trust have been embedded in us. And I think we need to allow that trust to build back up in this particular vaccine. And mandates is not the way you get people to trust or to gain trust in something. And until we protect our citizens from these mandates, they're definitely not going to come back and trust, because a lot of them aren't necessarily going to get it just because they're forced to. They're not going to. They're still going to be out there in the workforce. If we want people to actually get the vaccine, we need to gain their trust, not force them to do it. And again, at least until our medical workers gain trust in it, I don't think we can expect a janitor or a machinist or someone like that to have enough trust in the vaccine to get it and then rely on the fact that their careers are on the line if they don't.
Okay, David.
Thank you, Chairman. More of a comment. COVID-19 does not discriminate. It doesn't care what color you are, where you live. A woman's reproductive freedom does not kill people. You know, this kills people. And until
I'm just going to ask for a point of order. The representative is addressing me personally, like he's looking
I'm
at
not
me as he's
addressing
saying
you
this.
personally. I'm
So
just looking in your direction.
I would just like to say,
I think
because
you're paranoid.
I don't think there was an argument made on that. So if you're making that argument to me, I would ask that you make the argument to everybody else.
You're making it
I
about
didn't.
you. If I want to make it about you, I'll make it about you. But I'm not. I'm making a statement. And COVID-19 is a very serious statement. I'll look over here if it makes you more comfortable. You're not going to pick on you then. But, that's true. But it does not care. It does not discriminate. It will get you. And if we don't stop, we don't have time to wait and build people's trust, because this thing's moving too fast. And if we don't stop it now, then it's going to keep breaking off into different variances. It's going to get worse and worse. So we got to nip it in the bud. And it's great that this bill is getting people to talk. With this, what we always need to do. But the bottom line is, if you don't get vaccinated and you get COVID-19, you can trust where you're going to go. And that's as simple as that. Thank you.
Thank you. Let's, I know we started this bill to take care of one witness, which we still haven't taken care of yet. So if you wouldn't mind, we'll go to Rolf Hazelhurst. Mr. Hazelhurst? Hello?
Yes.
You are on the air. You have 8 minutes, please.
Okay, thank you. My name is Rolf Hazelhurst. I'm an attorney. I've practiced law over 25 years. For almost 15 of those years, I was an assistant district attorney general for the state of Tennessee. I currently work for Children's Health Defense. Neither I nor Children's Health Defense are anti-vaccine. Anti-vaccine is a disparaging term that's used to discredit and demonize anyone that dares to question any aspect of vaccine safety. I would like to briefly summarize the current federal laws regarding vaccines, specifically the National Vaccine Injury Compensation Act of 1986, the Supreme Court decision of Brusewitz versus Wyeth, and the Public Readiness and Emergency Preparedness Act, also known as the PrEP Act. In a nutshell, if a person is injured by a vaccine, they cannot sue the vaccine company that makes the vaccine. No matter how many people are injured, no matter how defective or unreasonably dangerous a vaccine may be, for all practical purposes, vaccine-injured people are prohibited by law from filing lawsuits against the vaccine manufacturer. To give you an example, if a child is injured by a vaccine under the National Vaccine Injury Compensation Act of 1986, the child is stripped of his or her legal rights. the right to a judge, the right to jury, the right to the rules of law are all taken away. Injured child's only legal remedy is what's known as vaccine court. Vaccine court is not a court of law. It's an administrative proceeding in which the most basic and fundamental rules of law do not apply. In vaccine court, the rules of evidence, the rules of civil procedure, and the rules of discovery do not apply. This applies to the PrEP Act. Now, in the Compensation Act and the Supreme Court decision of Switch versus Wyeth are both based upon the legal premise that vaccine injury is, quote, unavoidable. In other words, Congress, Supreme Court, control, HHS, and the American Academy of Pediatrics all recognize and agree that if you vaccinate enough children, eventually some of those children will suffer serious injury. Recognized vaccine adverse events include seizure, brain damage, and death. Since the Vaccination Act paid out over $0.5 billion, that's billion with a B, dollars in compensation for vaccine injuries. Now, the analogy can be drawn between penicillin and penicillin, miraculous cure for many, for others. Unfortunately, you get a game of vaccine, you don't know what category you fall into. Due to COVID-19 vaccine and the PrEP Act, 19 vaccines are not FDA approved or licensed under typical approval and licensing recommendations or requirements. COVID-19 vaccines are approved for use under the Emergency Use Authorization Clause of the PrEP Act. Vaccines under the PrEP Act, the pharmaceutical companies and under the PrEP Act, the pharmaceutical companies that manufacture vaccines cannot be held liable for defective or unreasonably dangerous products, no matter how many how many people are injured. And the point is, in the real world, if there is no liability, there is no incentive. I realize my time is short, so I'm going to give you one example. Pfizer and Moderna are using a process that includes and polyethylene glycol, also known as PEG. In September last, a letter to the Secretary of HHS and warned the use of polyethylene glycol in vaccines could cause very serious anaphylactic reactions in some people with pre-existing PEG antibodies. The script who would be at risk for anaphylactic shock and possibly death before the vaccine injection. HHS basically laughed us off and they dismissed our concern as, quote, theoretical. However, almost immediately after the massive rollout of the Pfizer and Moderna vaccines containing PEG, there were reports of people suffering severe anaphylaxis and death from containing COVID vaccines. The point is now known and recognized that anaphylactic shock, in some cases death, caused by the adverse reaction in the COVID-19 vaccines. A known previous reaction to PEG or allergic reaction to PEG should not receive the COVID-19 vaccine. So, 2 points. First, are legitimate reasons why people would choose not to receive a vaccine. The second is, as the COVID-19 vaccine is still in experimental stage of research. Vaccines typically involve years of testing in multiple phases, testing in the lab, tests on animals, tests on small numbers of people, tests on large numbers of people, really public license in a situation gone the lab.
Attorney Hazelhurst? Your phone keeps breaking up.
I'm sorry.
So
Can you
if
hear
you
me now?
Much better, but if you're moving around, your phone continues to break up a little bit, so we're losing some of it.
I apologize. Almost done.
Thank you.
Long-term safety studies have not been done. We're in essence guinea pigs, and the long-term effects and risks are not known. If people want to receive vaccinations, by all means, they should be allowed to, but people shouldn't be forced to receive vaccinations, especially not an experimental vaccine in which the long-term effects are not known. Now, pharmaceutical companies know that as long as COVID vaccines are not FDA approved under the normal licensing requirements, under the emergency use authorization, forced vaccinations would probably be struck down by the Supreme Court. But in the real world, there are laws prohibiting discrimination. People can and will be coerced directly and indirectly in receiving vaccinations. In my home state of Tennessee, I've witnessed firsthand people being economically forced into receiving vaccination. And I want to close one. The universal right of informed consent to medical interventions has been recognized by the U.S. law since at least 1914. The 1947 Nuremberg Code prohibits conducting research without informed consent of the individual. The Nuremberg specifically states the voluntary consent of human subjects is absolutely essential. So my main point is this: without protections against discrimination, true voluntary consent is not possible. Therefore, I urge you to pass this bill to prohibit discrimination against the unvaccinated. Thank you.
Any questions of Attorney Hazelhurst by members of the committee? Camilla.
Thank you very much, Mr. Chairman. I appreciate the testimony that the last witness had provided, but as my brother, Representative Noré, had mentioned, his voice kept popping in and out. I was wondering if it's not too much of an inconvenience for this witness, if he could provide us some talking points so that we could review everything that he said, because I don't want to miss any of it. It was very, very interesting.
That would be very helpful. Mr. Hazelhurst, can you do that for us?
Yes, I would be happy to, and I apologize for bad reception.
No problem. We'll give you some contact information with the person that will intercept you on the, or you can contact the sponsor. I'm sure you guys have been in touch. And you can provide him with the talking points that might be helpful to us to fill in some of the blanks where we lost you and lost your signal. Okay, any other questions?
Attorney Hazelhurst, thank you.
Thank you very much. Okay, now we're going to move on from this bill. Leave it, we have, I don't want to scare anybody, we got 48 other witnesses that we got to deal with. And they'll be much briefer as far as the time allotted. But we have the majority whip here before us, Majority Whip Kazarian. This is a bill involving family court and adoption, and I believe it specifically provides some changes as to the age involving adopted children.
Yes, that's correct, Chairman.
The floor is yours.
Thank you so much for letting me speak, and thank you to the members for listening to me tonight. The bill before you is very simple. It would reduce the age from 25 to 18 to allow adoptees to have unrestricted access to their original birth certificate. I will tell you that this bill actually came to me from a constituent who is an adopted child. And we spoke about, the ideas of what it's like to be an adopted child, some of the restrictions that are put on them. And really the way that this bill came about was, just like for non-adoptees, we have unrestricted access to our birth certificates. I don't believe there's anything in statute that puts a certain age on unadopted children and access to birth certificates, but I have heard the number 16 kind of being floated around to me. We want to make sure we're treating our adopted children the same way that we're treating our unadopted children. And by giving them access to their original birth certificates at age 18, we'd be bringing them closer to that number that we have for our unadopted children. One point I do want to bring that my constituent brought to me as well, is it's not just about reuniting with your original birth parents. A lot of it is about medical history. So it's really important to them, and I think it's something that a lot of the parents of adopted children and adoptees feel is important for them and would mean a lot to them to get it passed. So I'm happy to answer any questions, and thank you again for all your time.
Any questions of the whip? Thank you. Seeing none, we have a couple of witnesses on this bill. The first is Nancy Horgan.
Is important for them and would mean
Nancy?
a lot to get it passed. So yes.
All right, you're on the air, but you could first, if you wouldn't mind, turn down the volume on your computer.
Okay. Okay.
All right. Floor's yours.
Okay. Thank you, Chairman Craven. I appreciate the opportunity to speak in firm support of House Bill 6189. My name is Nancy Horgan, and I'm the mother of 3 grown children, one of whom was surrendered at birth, as I was afforded no other option as a teenager in 1968. I was haunted by the paperwork I signed under duress, and like a vast majority of young women in the same circumstance during that period of time, I wished for and waited for the day that my son and I would reunite. And we are both grateful that this did happen for us and are now celebrating 32 years back in each other's lives. I've worked on adoption reform legislation nationally, regionally, and locally for 3 decades in an attempt to help loosen the stranglehold held on adopted people who have been forced to accept that their original birth records were sealed for life. And I appreciated the support of the House when in 2011, the unrestricted access to one's original birth certificate bill was passed unanimously and did become law. Since the law was enacted in 2012, over 1,600 Rhode Island-born and adopted adults have exercised their right to access their unrestricted original birth certificate with no negative issues reported that we're aware of. There was a lot of media attention given to the change in the law at that time, and in 9 years, only 10 forms have been filed to the Vital Records Department requesting no contact at this time. Out of over 1,600, those 10 were filed in the first month after the law changed. Notice will be given to the media again, indicating further reduction should this pass to the age of majority, which is 18 in Rhode Island. More importantly, this provision that lowers the age of access from 25 to 18 will bring Rhode Island in line with other states that have not only restored this right for adult adoptees, but have also recognized the need for direct descendants of deceased adoptees to have access to family information. There's also a provision in this bill that allows for unrestricted access for adoptees born after July 2021, which would be in basically 2037. Surrendering mothers will be apprised of this component of the adoption law. Currently, the Division of Vital Records requires that children be at least 16 to obtain a copy of their original birth certificate, unless they have a signed letter from the parent or guardian, and I'm talking about children that are not adopted. So in 2037, an adoptee born after 2021 would be able to ask Vital Records for their birth certificate. This would be almost 100 years after Rhode Island sealed the birth records to the adopted, and I would hope we have learned better practices in adoption since then. And finally, I think there's always going to be some who feel that the state needs to forever delicately balance the rights of adult adoptees, their adoptive parents, and their birth parents. But I would respectfully remind the committee that adults, adopted or not, do not need their rights compromised due to the sensitivities of their parents. Adult people have numerous rights and privileges and need to be able to exercise them freely, whether their parents like it or not. Please know that this bill is widely supported by surrendering mothers like myself. It is simply a myth and not supported by fact that mothers do not want to know their adopted away children, that they are terrified of facing reality or are incapable of managing their interpersonal relationships without oversight from the state. This is an old and unfounded false narrative. The truth is, and this is supported by professional research, that mothers did not and do not seek to be anonymous from their children. We have moved out of the 1950s with the horrendous stigma on a mother placing a child for adoption. The vast majority of mothers support their children's rights to their unaltered original birth certificate. Passage of this bill will end once and for all the unfair and completely unnecessary state-held secrecy of one's identity, and I urge passage of this bill as written and offer my sincere gratitude for your consideration today.
Thank you, Nancy. Any questions of Nancy? Seeing none, Deborah Siegel is the next witness. Deborah, you're on the air.
Yes.
You can proceed.
Okay, thank you. And I urge passage of this bill as
Deborah?
written and offer my
Yes,
sincere
you have to turn
gratitude.
down the volume on your computer.
Got it. Okay. Thank you very much. I appreciate this opportunity to speak with you. Thank you very much. I'm Dr. Deborah Siegel. I'm a professor in the Graduate School of Social Work at Rhode Island College, and I'm here with multiple hats on. One of those hats is as adoptive parent. We were just listening to Nancy Horgan presenting her support for this bill as a birth mother. I'm here as an adoptive mother and as an adoption professional in support of the same bill. For the past 32 years, I've served as an adoption expert who trains adoption workers in agencies across the United States. I also provide psychotherapy with children who've been adopted and with their original birth parents and with their adoptive parents and the extended family members of both their birth and adoptive families. I have published in professional journals multiple articles on my original research on the outcomes of the relationships that emerge between a person's birth and adoptive families, and I've published encyclopedia articles and book chapters on adoption issues, including adoption ethics, adoption policy, and psychotherapy with people whose lives have been touched by adoption. I tell you all this about myself not to toot my own horn, but to let you know that my views are informed. They are evidence-based. They reflect the prevailing literature, the professional literature on adoption, and they are consistent with what's known as adoption competent practice. As Nancy Horgan was just telling us, secrecy in adoption has long been repudiated as harmful. It is not a best practice. Laws sealing original birth certificates are medically and psychologically damaging. Those laws are also lies, because today, promises of secrecy in adoption are impossible to keep. Why? Direct-to-consumer DNA test kits are widely available. Biological relatives have access now to discovering one another quite easily. Computers, mobile phones, iPads, and other electronic devices are everywhere, and it's impossible for a parent to control completely their child's access to those devices. In addition, social media outlets make it possible for even very young children to make contact with biological relatives on their own without adoptive parents' knowledge, involvement, or support. Hence, it's wisest today to plan for this kind of contact from the get-go, not to pretend that the secret of the child's original parent's identity can be kept. It can't. As a result of this changing landscape, every adoption today from its outset should have in place a plan agreed upon by both the original birth and adoptive parents for how to handle the possibility, the likelihood, that the adoptee will at some point have contact with their family of birth. Contact that any member of the birth or adoptive family or any member of their social network can initiate. Aiming to keep original birth certificates sealed is a pointless anachronism that stigmatizes adoption with the message that there is something so shameful about the birth parent or the adoptee that their biological connection must be kept secret from them. Sealing the birth certificate violates adoptees' basic human right to have the same access to information about themselves that is everyone else's birthright. Rhode Island's current law allowing adult adoptees at age 25 to have their original birth certificates is definitely a step in the right direction. Unfortunately, however, by age 25, many adoptees have already experienced medical problems that could have been avoided or effectively treated had they known more about their family medical history sooner. Similarly, by age 25, Many adoptees have already become parents themselves, and they have children with medical issues that could have been avoided or treated more effectively with more complete biological family information. So dropping the age of release of the birth certificate to age 18 is a step in the right direction. Eliminating the age limit entirely is vastly preferable. It's important to note that Rhode Island's current law gives birth parents the option of indicating their preference not to be contacted. This empowers the original birth parents with a way to make their wishes known. It empowers the adoptee with valuable information about the original parent's wishes. So it's time for us to tweak the current law. I understand that there is a letter from Judge Michael Fort from Family Court suggesting that the bill be tabled for further study. I understand the committee has already made that decision for all the bills being heard tonight. I do want to point out that 9 states already have unfettered access to original birth certificates: Alabama, Alaska, Colorado, Hawaii, Kansas, Maine, New Hampshire, New York. 37 states allow birth siblings of the adoptee to seek and release identifying information. So the proposed changes in the Rhode Island law tweak the current law in a very positive direction, and I wholeheartedly support it. I'm very happy to answer questions.
Is there any questions of the witness? Seeing none, then that would, thank you very much for your testimony, Dr. Siegel. That concludes testimony.
Thank you for the opportunity.
Testimony on House Bill 6189, which brings us to 3 bills involving Representative Shawcross-Smith, and First Vice Chair McEntee will handle those bills.
Well, good evening. Change of the guard. Anyway, Representative Shawcross-Smith, are you with us? Turn your mic on, please. The first bill is House Bill 6147. It's an act relating to criminal procedure, sentence, or execution, amends Hate Crime Sentencing Act, adds gender identity expression to protected groups, clarifies sentencing enhancements for hate crimes against victims in a protected group, and it permits sentencing to community service or educational classes. With that, Representative, you have the floor.
Thank you, Vice Chair, committee colleagues. I'm honored to be presenting this bill this evening, 6147. It was asked to me to be presented to the Attorney General's office. This act would amend the Hate Crime Sentencing Act to add a gender identity. This act will also clarify sentencing enhancements for hate crimes. It also will update the Rhode Island Hate Crime Sentences Enhancement Statute and add gender identity or expression to a list of protected groups. But from the Attorney General's office, we have Special Assistant Keith Hoffman, who is here to answer any questions that you may have. I thank you for this consideration.
Thank you, Representative. Do we have our first, any questions from the committee? Representative Aiello.
Thank you, Representative Shawcross-Smith. This looks really good. Thank you for introducing it. I do have one question now. Are there educational classes available now to which the offenders could be referred?
I truly don't know that. Maybe Keith Hoffman might know that. I know there will be classes of the community, any type of community harm. I don't know if they're in place at this time. I can give you that answer, or Keith can give you the answer.
Any other questions for the sponsor from the committee? Seeing none, we'll go to our first witness. Keith Hoffman? Hello, Keith, are you with us?
I am.
Welcome to House Judiciary. You have the floor on House Bill 6147. Please proceed.
Thanks so much. I'd like to thank Representative Shawcross-Smith for sponsoring this bill and the entire House Judiciary Committee for the opportunity to testify tonight. My name is Keith Hoffman, and I'm testifying in my capacity as the Civil Rights Advocate of the Office of the Attorney General. As a civil rights advocate and working with the entire Attorney General's civil rights team, I investigate and prosecute civil rights violations and hate crimes in the state of Rhode Island. Under Attorney General Nerona, we've really prioritized the prosecution of hate crimes in our state. In addition to creating the civil rights team, we recently organized the Hate Crimes and Civil Rights Liaison Officer program that every police department in the state is now engaged in. This ensures that hate crimes are properly investigated and pursued. Now, I want to start this evening with the facts. Across the country, hate crimes are on the rise. Over the last several years, we've witnessed horrifying hate-motivated mass shootings, an increase in crime against people in the Asian American and Pacific Islander AAPI community, and a rise of a new generation of bigots whose goal is to undermine the social fabric of our society. This bill is one part of a necessary response to the hatred espoused by those people who try to divide us and diminish the dignity of our diverse communities. It's definitely not the only response that's necessary, but it's an essential element in ensuring that prejudice in Rhode Island can be confronted and overcome. The Office of the Attorney General is obligated and really committed to protecting all Rhode Islanders. No person should have to live in fear of violence because of who they are, who they love, how they worship, or what they look like. The Attorney General proposes this legislation in order to best fulfill this profound responsibility by ensuring that the Attorney General can pursue hate crime cases when there's evidence that a perpetrator is motivated by the gender identity or expression of a victim. This is something that many other states have already done and really must be provided for under Rhode Island's hate crime law. Codifying the Attorney General's existing authority under the law to bring so-called mixed motives prosecutions in cases where the evidence demonstrates that perpetrators are motivated by both bigotry and some other motive. Ensuring that the Attorney General can bring an action in a case where a victim is targeted due to their association with a member of a protected group. That would be a case, for example, where a person is targeted because they are married to a person of a different ethnicity. The bill would also require a defendant convicted under the Hate Crime Sentencing Act to undertake educational or community service directly related to the community harmed by his or her offense, and would ensure that there is an appropriate sanction when a perpetrator motivated by prejudice destroys or defaces commercial or public property. Right now, under the law as it is today, it's unclear whether such a prosecution could go forward in bias-motivated cases involving public or commercial property. So, for example, last week, a local police department investigated a swastika that had been burned into public property with a blowtorch. There are no arrests yet in that case, but these amendments would allow a case like that involves property not owned by the person who is targeted due to the person's protected trait to be prosecuted under the hate crime sentencing statute. Finally, the bill ensures that community impact statements can be provided for district court cases where this is where misdemeanor hate crimes are generally prosecuted in the district court. With these amendments, the bill affirms Rhode Island's commitment to the fundamental principle that every person has dignity and thus the right to live free from discrimination, harassment, and violent attack. These amendments really provide necessary technical improvements to Rhode Island's existing hate crime sentencing enhancement, which is one of many sentencing enhancements under Rhode Island law, like those for domestic violence or certain firearm-related offenses or crimes involving elderly victims. While technical, though, the amendments to the hate crime sentencing law ensure that when hate crimes happen in Rhode Island, we have the right tools available to respond. And so, in that sense, they're really essential. Thank you again for the opportunity to provide testimony this evening, and I am, of course, available to answer any questions that you might have about this bill.
Thank you, Keith. Thank you for your testimony. I think it's a great bill. We're on the right track. Any questions from any member of the committee? Representative Aiello.
Thank you, Vice Chair Hagan-McEntee. Keith, how are you this evening?
I'm doing well. Thank you, Representative.
Good. Thank you for your really good overview. I had asked the sponsor, and now will ask you, are there available in the state right now educational classes directed at this issue, or is that something that needs to be developed? And If so, where? By whom?
Thank you, Representative. Yes. So at the Attorney General's office, we've worked with both organizations from in the state and also outside the state to line up educational and community service in certain cases. So the goal would be to provide for educational or community service that kind of gets at the heart of the hate crime, right? So if a particular group is targeted, well, then some sort of community service or education related to that group would be what we'd be looking for. And so, for example, the Holocaust Center has in the past agreed to provide this sort of educational programming. The Institute for Nonviolent Studies has agreed to provide very generously in both instances community service opportunities. So certainly there could be a need to develop that further in specific cases, but we have done some work here to set the stage.
Any other questions by the members of the committee? Seeing none, thank you, Mr. Hoffman, for your testimony.